I'm Dru Stevenson, and this is a video for my Law and Economics seminar about constitutional law and economics, and this is an overview video. So in this unit, we're going to talk about a number of different interdisciplinary approaches between economics and the study of constitutions and constitutional law. And in this video, instead of going in depth into any one of those, I kind of want to give a quick overview of the different types of interdisciplinary approaches or areas of study we've had. There's been quite a few, both in the United States and in Europe, regarding some studies of European constitutions and economics. And so, having said that, let's take a look, and then I'll have follow-up videos about some of these specific ones. So first, as we're starting with our areas of interdisciplinary studies for economics and constitutional law, is an economic theory of constitutionalism itself. So rather than talking about one constitution in particular, like the United States Constitution or its specific provisions, this talks about sort of the just the very fact that a country has a constitution and some of the economic properties of constitutions or consequences of that. And essentially, a constitution is a written textual document that requires some sort of supermajority, whether of the legislature or of the constituent states and or provinces, or both, as in the United States, in order to change certain legal rules. What this does is it means that there are certain sort of foundational legal rules and principles in our legal system that are quasi-permanent, right? So they're very difficult to change without a constitutional amendment or a constitutional convention. We can change it. We do have a number of times in our history that we have amended the Constitution, but it's very, very difficult and has become more difficult as the country has kind of increased in the number of states and Congress has increased in size. And this has a lot of implications, right? If you have certain laws in your legal system that are just regular regulations and statutes that can be enacted and repealed in a fairly routine way and then applied by the courts, and then you have other sort of legal rules in the system, sort of kind of either at the foundation or overarching sort of umbrella rules that don't change, that are semi-permanent, that has a lot of implications and consequences for how the legal system will operate. A second area of interdisciplinary studies for economics and constitutional law is the economics of constitutional design. And here we're talking about the structure kind of within the Constitution of things like separation of powers and federalism, and limits on the range and scope of future legislation. And so, as you can imagine, that we're going to have writers who talk about the transaction costs or the different economic features or rationales for or consequences of something like a divided government with checks and balances, or allocating and delegating certain powers to the states and certain centralizing other powers exclusively in the federal government, or putting boundaries on the topics of potential topics for future legislation, or the targets, the individuals that could be subject to that legislation. A third area of interdisciplinary studies for economics and constitutional law focuses on specific constitutional doctrines, like the exclusionary rule in criminal procedure. So in American criminal procedure, we have a sort of a judge-made rule. It's been around for over 100 years now, that the evidence that the government has obtained in violation of constitutional rights, like in violation of the Fourth Amendment, Fifth Amendment, or Sixth Amendment, is inadmissible in court, at least in a criminal prosecution. And there are some economic effects of that, and authors, including yours truly, who have written about what happens or what the consequences are of having specific doctrines like that. Is there an economic rationale, or what are the effects? Do things like the exclusionary rule actually work as they are intended, and so forth? Another example would be due process hearings. So the Constitution doesn't really provide for things like welfare hearings or license revocation hearings for your law license or your driver's license, but the courts have essentially said that the due process clause creates that, and there are a lot of there's a lot to talk about then when we talk about a due process hearing in terms of the economic effects, not just the effects on the economy, but what this does to governance and the incentives of the parties, and how the, let's say, a licensing system or a permitting system will work. A fourth area of interdisciplinary studies for economics and constitutional law deals with interpretation of the provisions that have an inherent economic logic. So from an economist standpoint, not all of the Constitution is created equally. Some parts are very easy to talk about in economic terms or to analyze economically. And an example would be the First Amendment protection of freedom of the press or expression, which is often defended in terms of sort of a metaphor of the marketplace of ideas, right? So the idea that if everybody can express their opinion and argue and try to win people over and convince others of their truth or the things of their beliefs, that we end up with a society that believes better things. The truth wins out in the long run, as long as we're not censoring the expression of certain ideas. And that if we have a competition, essentially the strongest ideas win out. And so that's an economic metaphor used to justify the protection of freedom of expression. You could justify freedom of expression a different way, sort of with some sort of philosophical deontological argument, or the concerns that censorship is always used to oppress disadvantaged groups or minorities or things like that. But there's a kind of a big body of literature arguing that free speech should be protected constitutionally for sort of an economic reason. And other clauses are the takings clause, the commerce clause, and the contracts clause, right? That essentially restrict the ability of the government to interfere arbitrarily in the market, right? In property rights or the rights of trade and contract. A fifth area of interdisciplinary studies for economics and constitutional law are basically kind of reform proposals. The idea that we should refashion constitutional law, either amend it or replace our document or interpret it very differently in order to make it protect free markets more effectively. And so the idea is that if you believe that free markets are basically the essence of freedom and the sort of necessary condition for a prosperous society and social welfare and so on, then we could tweak the Constitution, so to speak, to protect, let's say, imports and exports, and do away with the power of the government to impose tariffs and customs, or to regulate immigration and border crossings or things like that. And so depending on how robustly of a free market, like a free labor market or a free trade market you believe in, the Constitution as it stands now does allow for some interference with the free market. And for example, for Congress to regulate interstate commerce, and for the imposition of tariffs and customs. And so one area of study is for people to propose changing the Constitution to protect free markets in a more absolute way. A sixth area of interdisciplinary studies for economics and constitutional law is talking about the problem of double standards, or at least differing standards for different types of constitutional rights. So, for example, if you're looking at the Warren Court era or the Burger Court era, it's easy to get the idea that civil liberties were getting more protection from the courts than property rights. On the other hand, if you looked at the Lochner era, you might think that commercial rights were supremely protected. And a number of constitutional scholars nowadays would say that the current Roberts Court, sort of post 2020, is giving primacy to religious rights, or protecting religious groups, and their right to be free to sort of operate above the law, and so forth. So there is a question, for example, from an economic standpoint, do we see certain rights being given more weight or more operational power than others? And then there's a question of maybe they should, right? Maybe civil liberties, personal freedoms are more important than property rights, which tend to reinforce existing social hierarchies and social classes. Or maybe certain rights have been sort of subordinated for a while, and now it's their turn to receive more robust protection from the courts. You could think about things like voting rights, and whether voting rights are supremely important for the courts to protect, or less important because we have other mechanisms in a democracy to protect and sort out voting rights. A seventh area of interdisciplinary studies for economics and constitutional law is the relationship between having a constitution and economic growth. Now, one version that this takes is the idea that constitutional democracies have more prosperous and developed economies. Sometimes this is used as part of the origin story of the United States, and how the United States went from being a small sort of bankrupt republic after the Revolutionary War to being a global economic powerhouse within a few generations. And some scholars attribute that to the different aspects of the legal system that are embodied in the Constitution: the stability of the Constitution, the protection of property rights and contract rights, and the checks and balances between the branches of government, and so forth. And so this is the idea, and of course there are arguments on both sides, that if you have a constitution, that your country will thrive economically in the long run as a result. Okay, an eighth area of interdisciplinary studies for economics and constitutional law, it deals not with the text itself or the constitutional provisions, but how courts should interpret them, viewed from things like the idea of principal agent theory. In other words, we're talking about using economic insights to assess various interpretive approaches like originalism, or public good common good constitutionalism, or dynamic or a living constitutionalism, the idea that the Constitution evolves over time. And each of the kind of main schools of thought about how the Constitution should be interpreted has been justified using economic arguments, or arguments from law and economics. And that concludes my quick overview video lecture about the different types of interdisciplinary areas or study we have for applying economics to constitutional law. I will have some follow-up videos that drill down or explore some of these individual areas in more depth.